Well, thanks, Chris, for having me. This is a remarkable conference. I technically don't go to conferences because I find them tedious, and this is a conference that actually has kept me from looking at my phone, which is the highest form of flattery, praise I can think of, because I'm addicted to my phone like everyone else is. It's been so interesting. In my remarks today, I'm probably going to go over the 10 minutes because I'm going to be relying and making my argument on evidence that all the participants in the conference are very familiar with and have memorized. But I'm going to assume the students and other people in the audience are not familiar with and will therefore need to hear what these sources actually say. And so that will take me a little extra time to go through. The title of my talk is The Original Meaning of the 14th Amendment and Economic Liberty. In my remarks today, I'm going to defend the proposition that the original meaning of the 14th Amendment protects economic liberty. Now, to clarify the issue, let me begin by defining economic liberty. I define economic liberty as the right to acquire, use, and possess private property and the right to enter into private contracts of one's choosing. If these rights are protected by the original meaning of the 14th Amendment, then we can conclude that the amendment does protect individual liberty, economic liberty. Now, in my view, the evidence that the original meaning of the 14th Amendment protects the rights of private property and contract is overwhelming. But to say that the amendment protects the rights of property and contract is not to say exactly how these rights are to be protected. I'll return to that important topic after I discuss the original meaning of the 14th Amendment. After the Civil War, Republicans in Congress struggled to protect the newly freed slaves from the black codes that Southern states had adopted to reestablish white domination. In 1866, Congress enacted the first Civil Rights Act. This act mandated that all citizens of the United States, quote, shall have the same right to make and enforce contracts, to sue be parties and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property as is enjoyed by white citizens. So in this statute, Congress identified the civil rights of all persons, whether white or black, to include the rights to make and enforce contracts, to inherit, purchase, lease, sell, hold, and convey real and personal property. In other words, at the very core of civil rights in 1866 was the economic liberty defined by the rights of contract and property. But where in the Constitution did Congress find the power to enact the Civil Rights Act protecting the economic rights of contract and property against infringement by the states? It was the 13th Amendment, the first section of which prohibits slavery or involuntary servitude except as punishment for crime, and the second section of which gives Congress an enumerated power to enforce this article by appropriate legislation. To appreciate why the 13th Amendment protects the economic rights of property and contract, we must remember that slavery was, first and foremost, an economic system that was designed to deprive slaves of their economic liberty. The key to slavery was labor. The fundamental divide between the slave power and the abolitionists concerned the ownership of this labor. Could a person be owned as property and be denied the right to refrain from laboring except on terms contractually agreed upon? Or did every person own him or herself the inherent right to enter, with the inherent right to enter into contracts by which they could acquire property in return? Republican adherents of free labor held the second of these views. Therefore, by abolishing slavery, Republicans in Congress maintained that the 13th Amendment also ipso facto empowered them to protect the economic liberties that slavery had for so long denied. In particular, as the right to make and enforce contracts, to inherit, purchase, lease, sell, hold, and convey real and personal property. Defending the Civil Rights Act in Congress, Michigan Senator Jacob Howard noted that, quote, the slave owned no property because the law prohibited him. He could not take real or personal estate, either by sale, by grant, or by descent or inheritance. He did not own the bread he earned and ate. Howard then observed, quote, now, sir, it is not denied that this relation of servitude between the former Negro slave and his master was actually severed by this amendment, but the absurd construction now enforced upon it leaves him without family, without property, without the implements of husbandry, and even without the right to acquire or use any instrumentalities of carrying on the industry of which he may be capable. In sum, by abolishing the economic system of slavery, Republicans maintain that the 13th Amendment empowered Congress to protect the economic system of free labor and the underlying rights of property and contract that define that system. To the dismay of congressional Republicans, President Andrew Johnson vetoed the Civil Rights Act, in part on the grounds that he claimed it exceeded Congress's power under the 13th Amendment. In response to Johnson's states' rights argument, Supermajorities in both House and Senate overrode his veto. But some in Congress, such as Ohio Representative John Bingham, actually shared Johnson's concerns. Many in Congress were also concerned that when the Southern Democrats would resume their seats, they would repeal the Civil Rights Act, as they were loudly promising to do. They thought a constitutional rather than a statutory constraint was needed. So, pursuing a parallel track, Bingham worked with the Committee on Reconstruction to devise the 14th Amendment to constitutionalize the rights protected by the Civil Rights Act and more. Bingham drafted the Privileges or Immunities Clause, which read, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." Just what are the privileges or immunities of citizens of the United States? First, and most obviously, for the amendment to have performed the function for which it was adopted, these privileges or immunities must include the rights enumerated in the Civil Rights Act of 1866. That is, the rights of citizens to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property. These economic liberties of contract and property were, therefore, among the unenumerated privileges or immunities of citizens of the United States that neither Congress nor the several states may infringe. Nor could their protection be repealed by Southern Democrats when they returned to Congress. This conclusion is strongly supported by a speech delivered by the Senate sponsor of the 14th Amendment, again, Michigan Senator Jacob Howard. In his widely published speech, Howard explained that the substance of these privileges or immunities fell into two buckets. In the first bucket were the substantive rights that were protected by the Privileges and Immunities Clause of Article 4, which says that, quote, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states." Howard explained that under Article 4, quote, "Citizens of the United States are, by constitutional right, entitled to these privileges and immunities, and may assert this right and these privileges and immunities and ask for their enforcement whenever they go within the limits of the several states of the Union," unquote. Article 4 was limited to protecting U.S. citizens from being discriminated against with respect to these rights when sojourning in other states. But which rights of U.S. citizens were protected from such discrimination? To answer this question, Howard quoted from a lengthy passage of Corfield v. Coryell, the 1823 Circuit Court opinion interpreting Article 4 by Justice Bushrod Washington, who was George Washington's nephew. At the core of Justice Washington's description was this, quote, "What these fundamental principles are, it would perhaps be more tedious than difficult to enumerate. They may, however, all be comprehended under the following general heads: protection by the government, the enjoyment of life and liberty with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, subject, nevertheless, to such restraints as the government may justly prescribe for the general good of the whole." Washington was here quoting from the canonical formulation of natural rights that was originally drafted by George Mason for the Virginia Declaration of Rights. Mason's draft declaration was then incorporated into state constitutions. In Massachusetts, the Supreme Court relied on this language, the language in Mason's draft, and then the language that was in Corfield versus Coryell, to hold that slavery was unconstitutional in that Commonwealth, that is Massachusetts. As explained by Massachusetts Chief Justice William Cushing, quote, "Whenever sentiments have formerly prevailed, a different idea has taken place with the people of America, more favorable to the natural rights of mankind, and to that natural innate desire of liberty with which heaven, without regard to color, complexion, or shape of noses or features, has inspired all the human race. And upon this ground, our constitution of government, by which the people of this Commonwealth have solemnly bound themselves, sets out with declaring that all men are born free and equal, and that every subject is entitled to liberty and to have it guarded by the laws, as well as life and property, and in short, is totally repugnant to the idea of being born slaves. This being the case, I think the idea of slavery is inconsistent with our own conduct and Constitution." So the language cited by Justice Washington in Corfield versus Coryell protected the fundamental economic right to acquire and possess property of every kind. After quoting from Corfield, Senator Howard then continued, quote, "To these privileges and immunities, whatever they may be, for they are not and cannot be fully defined in their entire extent and precise nature, to these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution," unquote. Howard then proceeded to specify the enumerated individual rights guarantees in the first 8 amendments before offering this summary, quote, "Here is a mass of privileges, immunities, and rights, some of which them are secured by the second section of the 4th article of the Constitution, That's the Privileges and Immunities Clause, which I have recited, some by the first 8 amendments of the Constitution. He then explained that the Privileges or Immunities Clause of the 14th Amendment was needed because, quote, there is no power given in the Constitution to enforce and carry out any of these guarantees from state infringement. Quote, the great object of the first section of this amendment is therefore to restrain the power of the states and compel them at all times to respect these great fundamental guarantees, unquote. In his notes for his speech, Howard refers to these privileges or immunities as, quote, the fundamental civil rights of citizens. Having identified the language of the 14th Amendment that protects economic liberty from infringement by states, let me now turn to the separate question of how the Constitution protects these liberties. To understand this, we must set aside the modern conception of constitutional rights, in which rights are viewed as trumps that can never be touched by legislation. On the modern view, if one has a right, then legislatures can do nothing whatsoever to restrict its exercise. But this was not the conception of constitutional rights held by the founders or by the generation that ratified the 14th Amendment. For them, economic liberty, like all liberty, may be reasonably regulated to achieve a purpose within the competency of government. But the requirement that such regulations be reasonable imposes a limit on the legislative power. As Justice Joseph Bradley explained in his dissenting opinion in the Slaughterhouse case is, quote, the right of a state to regulate the conduct of its citizens is undoubtedly a very broad and extensive one, and not to be lightly restricted. But there are certain fundamental rights which this right of regulation cannot infringe. It may prescribe the manner of their exercise, but cannot subvert the rights themselves. He's distinguishing here between regulation, prescribing the manner of their exercise, and violation or infringement, the subversion of the rights themselves. The same is true, as Judd Campbell has shown, for the enumerated rights protected by the First Amendment. The fact that the Constitution recognizes the natural rights of speech, press, and assembly does not entail that these liberties may never be reasonably regulated. To the contrary, then and now, the courts routinely uphold time, place, and manner regulations of speech. On the other hand, the fact that these rights are fundamental privileges or immunities of citizens entails that courts must be on the lookout for unreasonable or arbitrary regulations that are designed to make the exercise of the liberties more costly or to stigmatize and deter their exercise. In other words, they must be on the lookout for legislative efforts to subvert these rights rather than reasonably regulating their exercise. It is the province of the judiciary to smoke out such illicit motives. As Chief Justice John Marshall wrote in McCulloch versus Maryland, quote, should Congress, under the pretext of exercising its powers, pass laws for the accomplishment of objects not entrusted to the government, it would become the painful duty of this tribunal to say that such an act was not the law of the land, unquote. This brings us to the Due Process of Law Clause in the 14th Amendment, which stipulates that no person may be deprived of life, liberty, or property without due process of law. The Due Process of Law Clause guarantees a judicial process before a legislature can deprive any person of their life, liberty, or property. This judicial process includes an assessment by an impartial judiciary that the law that is being applied to the individual is within the proper power of a legislature to enact. We have become accustomed to thinking of there being First Amendment challenges or Commerce Clause challenges to a congressional enactment. But while the First Amendment and Commerce Clause may provide the substance of such challenges, it is the due process of law which assures a process that includes an impartial judicial assessment of whether a congressional enactment is within its proper powers before any person may be deprived of their life, liberty, or property. Just as the Fifth Amendment's Due Process of Law Clause authorizes courts to ensure that Congress is not acting pretextually in asserting its enumerated powers, so too does the 14th Amendment's Due Process of Law authorize federal and state court judges to assess critically whether or not a state law restricting the privileges or immunities of property and contract are good faith exercises of the state's police power to protect the health, safety, and public morals of the community, or whether a state legislature's assertion of a health and safety rationale is a mere pretext, to use John Marshall's term, to pursue some other end that is not entrusted to state legislatures, like that of enriching themselves, or some favored faction or special interest group. I should stress that under the current Supreme Court doctrine, all restrictions on liberty, including economic liberty, are supposed to be rationally related to a legitimate state interest. But since the 1955 Warren Court case of Williamson v. Lee Optical, such rational basis scrutiny is satisfied if a judge can imagine any conceivable reason for the restriction. Such conceivable basis review is a denial of due process of law, which requires a meaningful or realistic assessment of whether a legislative act is within the legislative power before any person can be deprived of their life, liberty, or property. Of course, there is much more to say about how such judicial inquiries should be conducted so as to protect the rights, privileges, and immunities of the people without impeding the ability of legislators to reasonably regulate to protect the health, safety, and public morals of the people, and without creating a government by judiciary. But at this point, I'm afraid my time is more than up. To conclude, by effectively eliminating the Privileges or Immunities Clause from the Constitution and then employing a conceivable basis review of regulations, of restrictions on any liberty that the justices do not deem to be fundamental, the Supreme Court has undermined the rights of all Americans to make and enforce contracts, to inherit, purchase, lease, sell, hold, and convey real and personal property, the rights that both define and protect our economic liberty. But if there's a will to protect these liberties, there is a way that is both practical and grounded in the original meaning of the 14th Amendment. Thank you.
Good, John? My good friend Seth explained that we've done a lot of work on Section 3 of the 14th Amendment, and I want to give an overview of that here. Section 3 has a lot of text. It's jumbled together, and the text really does matter. And so there are four primary components of the text. I've numbered them out of order, so it's actually more helpful. First, who is subject to Section 3? If you took an oath as a member of Congress, or as an officer of the United States, or a member of a state legislature, or an executive or judicial officer to support the Constitution. This lines up with the Article 6 Oath Clause. Okay? Number two, if you took such an oath and then you engage in insurrection or rebellion, okay, that's bad. You can't do that. Third, if you took such an oath and you engage in insurrection, there's a consequence. You cannot be a senator or representative in Congress, an elector, president, and vice president, or hold any office, civil or military, under the United States. Unless, number four, Congress votes by 2/3 votes to relieve the disability. This is like a perfect storm for Donald Trump. Because almost every facet of Trump and January 6th is implicated by Section 3. So there are four questions, call them four Trump questions, if you will. So first, as Seth mentioned, can a Colorado court disqualify Trump, or is that a job reserved for Congress? Second, did the oath that Trump took as president, his only oath he ever took, did that subject him to Section 3? Third, did Trump in fact engage in insurrection? And fourth, is he then disqualified if he had engaged in insurrection from holding the presidency? Now, we can make these in legal terms, not Trumpy terms, right? In the legal terms, it's number one, does Section 3 require enforcement legislation? So, for example, 1983, we mentioned that before. Number two, is the president an officer of the United States? Number three, was J6 an insurrection? And if so, did Trump engage in that insurrection? And number four, is the presidency an office under the United States? These were all questions which people had probably never thought of before January 6th, but one guy did, Seth. Since, I don't know, 2008, when you 1Ls were like in diapers, I suppose, Seth had been writing, I'm exaggerating slightly, Seth has been writing that the president is not an officer of the United States. And at least in the Constitution of 1788, he says the presidency is not an office under the United States. This is not new. We were writing about this before it was cool. Seth persuaded me in 2013 or so. I was like, this guy's got something. I've been Tillmanized, right? He corrupted me, if you will. I don't know. I think he persuaded me, though. And there was a time when people agreed with Seth. So our good friend, he's still a good friend, by the way, Will Bode at Chicago, wrote that Tillman's theory makes sense of patterns that most of us never saw. It brings order out of chaos. As maybe Seth's keynote looked a little bit chaotic. Trust me, order comes from the chaos. And we developed this theory. We have graphs explaining how the different language in the Constitution, we have officer of the United States. We have office under the United States. Where's the clicky thingy? I don't know what the clicky thingy is. Anyway, office under the United States and office under the authority of the United States. All these different phrases. Thank you. That's not clicky thing. All these different phrases have different meanings. Now again, no one cared about any of this until Trump. Because when Trump came to office, oh, I got a clicky thingy. Awesome. When Trump came into office, he had a hotel. It was a few blocks from the White House, the International Hotel. And when you know it, all these diplomats did business there. So almost immediately, the resistance, la resistance, right, emerged. And they said, emoluments. What the heck is an emolument? This is a clause of the Constitution that says certain people can't accept gifts or emoluments from foreign governments. Now, this has been basically a relevant provision no one cared about except for Seth and maybe two other people. But one day in 2016, I said, hey, Seth, Trump won the election. It looks like there might be some litigation on this. You want to do an amicus brief? Oh, little did I know. So between 2017 and 2021, Seth and I filed amicus briefs in, I lost count how many courts, a lot of courts. And we stirred stuff up, you might say. We argued that this phrase in the emoluments clause, office under the United States, that does not include elected officials. That means only appointed. Therefore, Trump is not subject to the provision. We also made arguments about what an emolument is. And we got some evidence on our side. George Washington accepted gifts from foreign governments. If you go to Mount Vernon, you will see the key to the Bastille and this gilded painting hanging on the wall. They've been there. Every school child has seen it. We don't want to talk about that. George Washington was a lawbreaker. Sensing a pattern here. Thomas Jefferson, if you go to Monticello, there are gifts hanging on the wall from the Indian tribes. These were indeed foreign nations. They were foreign nations. Trust me, they were, as Justice Gorsuch. They were foreign nations. And we have evidence from Hamilton, Alexander Hamilton. He was asked to list all those holding office under the United States. He did not list the president. Except, to the point before, some historians went to the National Archives, and they found a document. They said, wait a minute, no. Blackman and Tillman are wrong. Hamilton did list the president, and they're wrong. You got to read the footnotes, Professor Graber will tell us. So this is the first New York Times article about Seth, first of many. We ignited a storm. It turns out the vaunted historians, they were not looking at a document that Hamilton himself signed. It was a copy, a Scrivener's copy made years later. And to their fairness, they've retracted, they've apologized, but it just gets started there. Since Trump came into office, the norms, the standards have changed. People have made claims in blog posts, and they've run with those blog posts in ways I think have frankly been reckless. Always check the footnotes, as one might say. So come 2020, we were like, okay, we have an election, and Biden won. He won. And Biden won the election. And we thought, okay, you know what? We're done with this officer stuff. Let's go back to writing about our boring lives and other stuff. But then January 6th happened. And that day, both Seth and I realized, oh crap, we're back in the game, right? It's like The Godfather. We keep trying to get out and no, we're going to bring you back in. It's office stuff again. Why? Section 3 will turn on office. Was Trump in office for the United States when he took the oath? Is the presidency in office under the United States? We cannot escape Trump's gravitational pull. We keep trying to get out. It's like a black hole, the event horizon. We're in. We just keep going towards the event horizon and eventually the singularity, right, which might happen in about 2 months. We are stuck in Groundhog Day with Bill Murray. That's truly how we feel. So on January 7th, we started writing an article in the 5,000 Chris mentioned about is the president in office for the United States, published in a very good journal, the NYU Journal of Law and Liberty, published many times. And at the time, no one really cared, didn't really generate any buzz, but we knew that if Trump got the nomination, or at least looks like he was getting the nomination, this would be a big deal. So again, no one cared when the little me and Seth from Texas and Ireland wrote an article, but the New York Times again published a spread on Will Bode and Michael Paulson. And they argue that, yes, Trump must be disqualified. In fact, it'd be reckless if he's not disqualified. The essence of democracy is taking a person off the ballot. That's what we learned the last year. And Mike and Will are not just anyone. They are respected conservative scholars. The best way to be a conservative scholar gets respect is to help someone on the left. That's just a known quantity. So they got all of this press. And again, our article didn't get any New York Times attention. Theirs did, because it served a purpose. Now, to their credit, Bode and Paulson discussed me and Tillman in their article. And they say Blackman Tillman is a textualist approach, hidden meaning hermeneutics, whatever that is. It's a secret code discernible by a select priesthood, these two Jews, or this priesthood of Illuminati, right? That's that's where we are with Seth, with Michael and Will. Oh, Akil Amar. Oh, Akil, his name hasn't been mentioned today. It sounds like Beetlejuice. We say it 3 times, he'll show up and wave a book around, right? Let me be clear. This is a stupid argument on the merits. I'm going to demolish it. It's embarrassing. So people were attacking us. Seth was mentioning Professor Graber. I'll mention a few others. This is how we roll, right? We just say stuff and just get eviscerated from all corners. And we don't give a damn. Do you know why? Because the district court agreed with us. Judge Sarah Wallace, a Denver trial judge, had one holding that actually mattered. She said Trump, as president, was not an offer for the United States. And she didn't cite us. She didn't have to. But the arguments that she brought up were the ones that we advanced and the Trump lawyers relied on. But the Colorado Supreme Court reversed. And the Colorado Supreme Court said, no. Of course, Trump's an officer. Did not engage with any of our arguments. They ignored them all. Indeed, one justice, Justice Samore, interesting guy, cited us. And he explained that the 14th Amendment requires enforcement legislation. All right, so let's jump ahead. The case goes to the Supreme Court. Tillman and I put in an amicus brief, just showing how much nerve we have. We also sought oral argument time. We do this when we denied, but it's a good trick. If an amicus wants to file a reply brief, just seek argument time. That's all you have to do. There are no word limits on it. Get around it. We've learned stuff over the years. And the case goes to the Supreme Court, and something like that, I think. And on the eve of argument, another New York Times article at Tillman. What is it with this guy, right? I'm like his promoter, I suppose. An outsider, an offbeat theory in the fate of the election. Akil Amar calls him the most interesting person in the world, exaggerating slightly. Okay, and here's me and Seth at the Supreme Court. Oh, we're just looking so happy. And you can see COVID was not good to me. This was us a couple years ago, because Seth looks the same. But my hair just keeps getting bigger, I suppose. So during the argument, I promise I'm going to get to some law. During the argument, this issue did come up. And is the president an officer of the United States? Is the presidency an office of the United States? And really, there were 3 camps here. The Justice Kagan camp, the Justice Gorsuch camp, and the Justice Jackson camp. So Justice Kagan, and I was sitting a few rows from her, said, is this a sensible rule, right? Does this make sense that the president's not excluded? And Justice Gorsuch comes in and says, this is very Gorsuch, very on brand. It may look odd to us today that the president's an officer of the United States, but maybe that's how it works. That's the language that they understood. If we are immersing ourselves in the world of the 1860s, how would this have been understood? And then Justice Jackson, who, frankly, I was pleasantly surprised. She came out hard-hitting on this. She said, the history actually provides the reason for why the president's not included. They weren't worried about the president. They were worried about Southern Confederates. This wasn't on their mind that somehow someone would become the president of the United States. Okay? Now, in fairness, it lines up. Oh, watch it. I'll do it again. Ready? So Kagan, Gorsuch, Jackson. Oh, here it is. So the first approach is the Bode-Paulson approach. I'll do it one more time if you missed it, right? Boom. Magic. Right? So the first approach is Bode and Paulson. Like, what's a sensible rule? And if you read their paper, these words sensible a million times over and over again, right? The second one, the Gorsuch position, is Blackman and Tillman. Gorsuch, whether he cites us or not, I don't really care. But he was saying our position. And Kurt Lash was the Jackson position, number 3. As Seth mentioned, we've never taken Kurt's position. We actually respect it, we understand it, but that's never been our position. But for Bode and Paulson, what's a sensible rule? What's a straightforward rule? This is how the textualists approach it. What's sensible? It makes sense. Sense and common sensibility. I won't read them all, but if you control F their paper, which is the best thing to do with their papers, they're long. I didn't read their new one, I'm sorry, but I'll get to it eventually. Just look for the word sense and sensibility. They just use this over and over again. This is textualism, I guess, what makes sense. But Justice Gorsuch is a textualist to the extreme. He's hardcore textualist. And he says, so maybe the Constitution to us today, to a lay reader, might look a little odd in distinguishing between office and officer, not prepositions, nouns, a distinction, but maybe that's how it works, right? He observed that the Speaker and the Senate President pro tem are officers because the Constitution says they are. But they can't hold an office under because of the incompatibility clause. I want to explain that now. Gorsuch gets it. And Justice Jackson, too. Again, when she says she's a textualist, I believe her. I didn't believe her before this day. I believe her now. She knew these points backwards and forwards, and she walked through all the arguments. I don't see any evidence that the presidency was on top of their minds, right? I thought the history provides a reason why the presidency is not included. And what was frustrating as heck is that the lawyer for Trump was fighting her, Jonathan Mitchell. He was actually like pushing back against KBJ on this, which is not the card I expected to play that day. All right, and Kurt Lash got it in. But then we have Justice Sotomayor. Kurt Lash, right? Then we have Justice Sotomayor. And she kind of got a little mad at Mitchell and really kind of mad at me and Seth in a way. She says, a bit of gerrymandered rule, isn't it? You're having a rule that only benefits Trump? And then Sotomayor says, well, you didn't make it up. I know some scholars have been discussing it. Some scholars. Put that on my tombstone, right? Some scholars. Dare not mention our name like Voldemort, right? Just some scholars. Here's some more scholars. It's me, Bowden, Paulson, lots of scholars. So the bottom line is, I'm almost out of time, is that the Supreme Court didn't decide any of these issues. Or maybe they did, but they didn't really decide it. The court went its kind of own way. They had a ruling based on execution and whether it was a statute, but they didn't touch the officer issue. So we're left in this weird limbo land where, depending what happens in, 2 months or so, we might be in for a painful awakening. Because just imagine that Trump wins the Electoral College, but there are Democratic majorities in both houses, which is possible. Do they disqualify Trump on the floor on grounds of insurrection? Will, Michael Luddy be the new John Eastman, right? Just flip roles. That Kamala Harris has a duty to gavel out any votes for Donald Trump. Well, everything just reversed what it was 4 years ago. So the court didn't decide this issue, perhaps not its best decision, but we now have this going forward. All right, so we had Section 1. I did Section 3. Are you doing Section 2? No. Okay. All right. Well, we got Section 1 done. We got Section 3 done. We'll talk more. Thank you all so much.
All right, well, good afternoon. Something with voting rights. So, something voting. Well, and first of all, when I was on the plane yesterday, sort of reviewing my notes, I was thinking, oh, thank goodness I don't have to do the theory of disqualification. We've talked about that a lot. I am going to talk about something different and alluding to the first panel and the discussion where Professor Upham mentioned protecting black in participation in the political process. This is where I come into this conversation today. In particular, although different, because while I'll start with history to a certain extent, it is a very different history. And in some ways, sitting here today and feeling very engaged by these conversations has reminded me that things happen very differently in election law land. And by that, those of you who are familiar with the detailed test can think about the Anderson-Burdick balancing test, which based upon the 14th Amendment and the Equal Protection Clause actually then balances rights between the state and the claimant that the state's regulation is somehow inhibiting their ability to vote. And then even to give the shout out to Section 2, right, the Section 2 representation, or I should say anti-disenfranchisement provision, speaks to how the text is talking towards ensuring that states don't go around and disenfranchise, creating a penalty for that. And of course, Fernita Tolson has the corner on the market of that sort of thing. I want to talk about something different though, but in noting these things, right, there is this concern about race and representation. And I want to give you an account that looks at color blindness as part of this formula. And we've hinted at the word color blindness as sort of not looking at race. And indeed, the modern court, as recently as Alexander versus South Carolina NAACP, pointed to this as a purpose of the 14th Amendment. To quote Justice Alito, the 14th Amendment was designed to eradicate race-based state action. citing SFFA versus Harvard. So this struck me as a very interesting proposition and sort of the end point of an arc that I will tell you about in terms of how color blindness in the election law context, and specifically in the context of talking about racial gerrymandering and the parallel sort of claims in the redistricting context around Section 2 racial vote dilution have evolved. And so I want to talk about that evolution, and I think of this as a post-racial color blindness that the modern court has created, right? A color blindness that eradicates state-based action on the basis of race, on the justification that race has changed enough in our society and is no longer a problem to the extent that it was. You hear shades of Shelby County versus Holder there. And so to talk about that, I want to talk about those three groups of cases, but I want to start with something different, which is to begin, one, with the idea that, of course, the notion of color blindness in this context, at least for me, starts with Harlan in his dissent in Plessy, right? And what has become sort of a clarion call for the 20th century and maybe even the 21st, our Constitution is colorblind. But when I teach this material in election law classes and civil rights classes, I always read the whole paragraph to my students, right? Our Constitution is colorblind, but to read the whole paragraph, the paragraph begins, the white race deems itself to be the dominant race in this country, and so it is in prestige and achievements in education and wealth and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in the view of the Constitution, in the eyes of the law, there is no country, no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens, and goes further from there. So you have a paragraph that tells two different stories: white supremacy and colorblind constitutionalism. And I would go so far as to argue, in terms of scholars, at least critical race theory scholars, who have argued that those two things cannot be separated. A provocative claim, I admit, but it sort of helps understand at least where I come from in terms of looking at these issues, right? If you think about Plessy and then just look a few years later to Giles versus Harris, where Jackson Giles petitioned the Supreme Court to put a stop to the hijinks that were happening in the state of Alabama, where African American men were being subject to poll taxes, literacy tests, all the hallmarks of Jim Crow era voter suppression, but white men were not. Largely, they were exempted by grandfather clauses, which the court later found unconstitutional as a distinction on the basis of race. But the court, of course, upheld things like disenfranchising women and the enforcement of poll taxes. See Minor v. Happersett and Breedlove versus Stuttles, similar in that era. But of course, the Giles court said, well, I'm sorry, we can't help you, because if your claim is that the Alabama disenfranchisement system is unconstitutional, and for noting situation, you know, they were implementing what was called the Mississippi Plan of poll taxes, literacy tests, and the like to target poor and undereducated African American men. And Giles's argument, by the way, was, but I am educated and I can pay these taxes, and yet you are shutting me out of the system. Now, given all that, the court said, well, if you claim that the system is illegal, and if your remedy is that we force the state of Alabama to enroll you in the political process, then we would be helping the state of Alabama do something illegal. And that is something we cannot do, says Oliver Wendell Holmes. of course, he then also says, well, ultimately, this is up to the states anyway. This is a political question, at least that's what we would call it today. And therefore, this is not our role. And in effect, he's saying, well, if Alabama wants black people to vote, it's up to Alabama to do so. Which strikes me, to use the words of Lonnie Guinier, as the ultimate expression of tyranny of the majority in the face of what was implicit in the 14th Amendment, as we've already illustrated, and was explicit in the 15th Amendment, that there be no discrimination on the basis of race when it comes to voting. Of course, there was a corrective to this in terms of the Voting Rights Act. And we're all familiar with the two major provisions of the act, but if you haven't heard them, there was Section 5, which basically said states like Alabama with a history of this discrimination have to have their laws approved before they're implemented in the electoral process, right? This process was called preclearance. A state like Alabama or Mississippi or others under that regime would have to have their laws approved by the Department of Justice, and if they didn't like what the Justice Department did with it, they could take it to court. And so the federal district court and the District of Columbia had jurisdiction. And then there was Section 2, which was basically the general provision that enforced what was implicit in the 14th Amendment and explicit in the 15th Amendment, that there be no discrimination on the basis of race, particularly any law that would, according to the 1982 amendments to the Voting Rights Act, Section 2, any law that would have the effect of harming people of color in terms of their ability to participate in the political process could be a target of a Section 2 suit. And the courts are commanded to look at the totality of the circumstances to see if those minority communities are being harmed. Now, there is a parallel. The focus here, though, is on the 14th Amendment, and there's a parallel theory of racial gerrymandering that evolved in a case called Shaw v. Reno from 1994, which ironically is tied to the Voting Rights Act. So under those 1982 amendments, the view of the Clinton administration was that there should be certain proportions, arguably, or at least minority opportunity districts committed or created by states in order to provide for more proportional representation without there being literal proportional representation, because the 1982 amendments explicitly outlaw that. But the point being that the Clinton administration was in negotiations with North Carolina. The North Carolina legislature drew a very snake-like district that stretched, if you know your map of North Carolina, or you can just Google Shaw v. Reno map, you'll see it's very strange and elongated, and it snakes from Charlotte all the way to Durham along I-85. The court looked at this and basically said, look, it is so clear to us that race predominated the process here that it offends the Equal Protection Clause. This is, in the words of Justice O'Connor writing for the court, political apartheid. And so in that sense, we have this sort of view that that race can become offensive if it becomes the prime objective. So in this sense then, and I don't have that much time, but I could talk about the evolution of the standard from one of a kind of we know it if we see it kind of approach to one that basically says if race predominates and to the exclusion of other considerations like partisanship or preserving other aspects of communities in doing the redistricting process, then it is unconstitutional. Now, there was a recent case last term called Alexander versus South Carolina NAACP, where this racial predominance test was put to measure, right? In South Carolina, after the 2020 census, there was a number of population shifts, and so South Carolina needed to redistrict the Charleston area. And then there was the 1st Congressional District and the 6th Congressional District. To make a long story short, around 55 or so thousand black folks were moved from the 1st District, which I believe was Jim Clybourne's district, prominent African American representative from South Carolina, to the 6th District. The state argued, well, this was in order to make sure that the 6th District would be balanced, yet accomplish our goal of making the 6th District more reliably Republican. And the plaintiffs in this case basically argued you move those people because not because they voted Democratic, but because they're black. And so, as Justice Kagan put in dissent, well, the question is a factual one of why that happened. And the district court pointed to the fact that the districting metrics had explicitly said there is a target of 17% black voting age population for District 1, and given that explicit target, race predominated. The Supreme Court rejected this, and Justice Alito, speaking for the court, basically said, look, the standard is racial predominance. That means race is the primary priority. You thus have to show me that race subsumed partisanship or other considerations. In looking at this evidence, we can ultimately tell not that race predominated, but that there seems that it could be an either-or explanation. And so given that the evidence could be read either way, we cannot conclusively say on this evidence that race predominated. So the racial gerrymandering claim was rejected. In particular, he spoke to a notion of the idea that there should be, in essence, a benefit of the doubt given to the legislature, or as he put it, there's a presumption of legislative good faith in drawing districts. Now, of course, the problem with South Carolina, and particularly throughout the South, race and partisanship highly correlate. So this question of how can we tell whether it's race or how can we tell if it's partisanship becomes difficult. Now, of course, you could imagine a different world, as Justice Kagan did, that this isn't about anything other than race, right? The evidence seems clear, and that given litigation standards, we should defer to the district court that has the clearest eye on the evidence. So, and moreover, she rejected this notion of deference to the legislature and the presumption of good faith. Now, the point here is that this question of deference to the legislature seems to me to become more and more crucial to the way that the court thinks about these things. And the provocative point here is that that sounds a lot like the deference to the legislature that was in Giles. And given that that opened an era of racial voter suppression, I want to leave us with the question of whether this, couched in a world of post-racial colorblindness, where eschewing race, ignoring race, or even to go so far as SFFA's point of saying race-conscious race-conscious state action is to be eliminated, would create a problem of creating a status quo where this tyranny of the majority can play out and the federal courts refuse to take a role in it. I mean, we can talk in the Q&A about other attacks on the Voting Rights Act, but if we take that as a given, then I leave you with my deep concern about whether we are facing another era of white supremacist racial dominance. Thank you.
Thank you all. I have two questions actually for Professor Ellis here. The first one, thinking about the Shaw cases, I'm curious, you spent a little bit of time on this idea of disentangling race and politics. Do you have a view on whether that's a worthwhile enterprise? I mean, obviously people have argued that it doesn't really make sense to even try to disentangle them. That, for example, in important senses, party identification and race kind of are the same thing. under in particular context. So if that's true, then the whole idea of disentangling becomes kind of pointless. So then I'm throwing that. I'm just curious what your view is in that debate. That wasn't a leading question. I don't know what I think, if it's impossible or not. Just curious. And then your point on deference made me think about this with respect to the Voting Rights Act. The Voting Rights Act is and was in Section 5 a regime that was quite non-deferential to states to which it applies. And so I'm curious if there is anything that you think the Voting Rights Act can tell us about either the meaning of equal protection in the 14th Amendment or the set of permissible meanings in the 14th Amendment with respect to equality.
So I think to your first question, I wrote a little bit about the racer party problem in an earlier piece looking at North Carolina in a vote denial context, sort of being accused of the same thing. And there I basically took the view that, yes, disentangling strikes me as a pointless enterprise, and that if it is, in essence, if we're looking at a discrete and insular racial minority here, then disentangling shouldn't be the point. It should be, well, we're targeting folks on the basis of race that might correlate with party, and the presumption should be against it. So, yeah, I would agree with the notion that I'm not sure that, because to me, this notion of giving deference strikes me as allowing states to explain away race-based action that might be disabling of the minority groups under the guise of partisanship. And I think that that does not strike me as a useful or fair exercise. As to the original meaning of the 14th Amendment, I'll only just say that I think there is, echoes of the Reconstruction era that were trying to be recaptured in terms of the statutes that were passed at that time, specifically targeted at creating space for, African American political power to have its existence. And I think that to the extent that that is an end, that might help shape our conversations about what the original meaning is.
Potential softball for Professor Blackman. You and your co-author have been accused of being quibblers, and so the idea being that maybe the drafters weren't quite as pedantic about the language that they're using. So I wonder what your best argument is, or how you might satisfy the proposivists, and you might talk about this already.
Sure. And Professor Graper made this point at dinner last night. We don't know a lot about where Section 3 came from. I mean, we know it was introduced, but it was written in these various caucuses, and there's some records of them, some not. But we don't know exactly why they chose the language they did. But we know what it was similar to, right? The language about office of the United States tracks the Article 6 oath clause. It's almost the exact same language. We had George Washington Pascal writing within a few years of ratification that this is exactly the same positions that are covered by Article 6. We know the president is not covered by the Article 6 oath clause. He has his own oath, right? So if you take, as Frankfurt would tell us, sort of old soil, you bring the meaning with it. Even if they didn't intend to it, that's what the meaning means. We are original public meaning originalists. We're not proposivists. But even then, if you want to be proposivist, arguably they were worried about Jefferson Davis, and I can't deny that, right? That's a Kurt Lash issue. They didn't want Jefferson Davis to become president. But they didn't think about a person who took one oath, only one oath as president, then engaged in insurrection, and then sought to be reelected, right? Jeff Davis was a senator. He was squarely covered. So the sort of the fact pattern for our position is one that no one could have imagined until Donald Trump came along. But that's the world we live in, right? Not everything is covered by the intentions of the framers and by their purposes. So we stuck with meaning. And on meaning, I think we have a lot going for us. Quibble me this.
So in 1862, when they have the Second Confiscation Act, there's a bunch of fussing over who exactly it applies to. So a lot of these verbal formulations get trotted out in different formulations. So in 1866, so this language kind of just appears between May 23rd and the 30th, they initially restrict voting, and then they come back. Oh, let's restrict office holding. But I mean, the place to go for what are they thinking of? What could they possibly be trying to do with it? That's just 4 years old, and then of course you've got all this of and under and just all the stuff from the original Constitution that they may or may not have had that squarely in mind, but they just as had in 1862 this whole big, and there's a huge amount of due process language there. So I don't know. That was underexplored, let's just say, in Trump v. Anderson. So further down the road.
Got a quick question for Professor Ellis. I'm curious to hear your thoughts on some of the recent debates about the effectiveness of state courts to, I guess, address both racial and partisan gerrymandering. So you focus mainly on federal courts. I'm wondering if you think there's still some role, racially progressive role, for the federal courts to play, today-ish, and whether you have any thoughts on the potential effectiveness of a state court strategy.
Well, if you saw my notes, you'd see that there's a whole page about partisan gerrymandering that I X'd out. So that page in 30 seconds. Well, I mean, actually, let me come back to your first question, right? I was presenting with Rick Pildes at NYU last week, and of course he was instrumental in sort of the creation and the evolution of the racial gerrymandering doctrine, and he made a great point that there was a period sort of before Alexander and some of these 2020s cases that racial gerrymandering was a shield. I think he argued Alabama Black Caucus versus State of Alabama, which was basically the Black Legislative Caucus argued that the state was basically trying to gerrymander their seats out of existence, and the Supreme Court upheld that claim, right? So I think the fairest notion of the racial gerrymandering doctrine is that this is a thing that can both prevent states from overly participating in being pulled by the Voting Rights Act, but it can also protect Black incumbents, right? That case is an example. So I think it goes both ways, and I think it is, and I even wrote a blog post in the wake of that case making that point. Like, it can go both ways and can be a shield. So I think state courts are instrumental around partisan and racial gerrymandering claims, right? If we take the premise that these two things correlate, a partisan gerrymandering case argued well actually helps fix racial gerrymandering problems too. And so state constitutions are far more robust because they have many of them have explicit commendations to prevent undue partisanship gerrymandering, right? And this is also a thing for activism, right? There's an amendment in Ohio that's going to be voted on in November specifically to take gerrymandering out of the hands of the legislature and put it into the hands of a citizen commission. And so those structural fixes are, I would add those to your list as well.
First, thank you very, very much. And as always, I'll say you can read the articles and read the footnotes. But if I could put a codicil on something Randy said and ask all three of you about it, I think it's clearly right that particularly a number of framers said, well, if the Democrats come back in power, there's always the courts. But as I read the debates and the commentary, I think the framers thought the courts were a bit like a modern emergency brake. You shouldn't expect it to work very long or for very long. And the question for all three of you is, you three of you have very different understandings of the 14th Amendment. But can any of your understandings work very well or for very long if Congress, which the framers expected to be the primary implementer, if Congress is on the sidelines?
Well, I think part of the problem, Mark, is that the court has put Congress on the sidelines. by neutering its Section 5 powers under the 14th Amendment. So I think that Congress has tried to exercise its powers, and it's been told that it can't do it in a variety of ways, sometimes by limiting Section 1. So if you limit Section 1 to state action, then you're going to bar Congress from protecting something other than state action. And since I do think the limits of Section 5 is limited by the previous 4 sections, what Section 5 authorizes it to do. But if you overly narrowly construe Section 1, I'm not going to say anything about your sections, but at least Section 1, then you're going to obviously you're going to put Congress on the sidelines as well. The other thing that Evan and I point out in our book, which it really hadn't occurred to me at all until we worked on the book together, and that is that courts may be just institutionally incapable of generating remedies on a case-by-case basis, just because they adjudicate cases one at a time. So it'd be very difficult for a court to impose obligations on state governments on the basis of one case. What are they going to do? We've seen examples of judges taking local governments or prison systems or police departments under their direction, which I think is usurpation by the courts. Congress, on the other hand, is capable of creating remedies, and something that Josh and I have emphasized in our casebook, Strouder, was a state bypass law. It was a law that created it didn't invalidate West Virginia's jury selection law. It said when West Virginia's jury selection law was racially discriminatory, you can have this federal cause of action within our power to create. A federal judge could not have created that system of remedies, but Congress can. So I think I basically agree with you. And so the point that Evan and I make in our book is that identifying the meaning of Section 1 might still lead to an argument for under-enforcement by the judiciary, while allowing fuller enforcement by Congress. Or put another way, I'm sorry, I'm meandering here. If the logic of the Supreme Court is that Section 1's meaning must be limited because competence of judges are limited, that doesn't apply to whether the competence of Congress should be similarly limited, which is, we believe, what the court has said. We take a judicial restraint approach to Section 1, and therefore, since Congress's power is limited to what we say Section 1 is, now we're going to limit Congress's power due to considerations that relate to judicial incompetence, and that we think is a mistake.
One of the big mistakes. Justice Breyer makes this point in I think 2001, where he talks about what a big mistake it is to use these old rational basis cases on like age discrimination or disability discrimination and using them to limit congressional power. The way I would think of it, Section 1 can be enforced by courts if it's clear. And if it's clearly outside Section 1, then Congress doesn't have the power. But because there are so many unclear cases, that's where all the congressional power comes from. It's the power to clarify Section 1. The power to enforce is the power to clarify. But not everybody would kind of put the pieces together in quite that way.
Professor Ellis, do you think the problems that come about, whether you catalog them under partisanship or racial discrimination with regard to voting, in first past the post, and maybe could be solved if we had ranked order voting for all seats common across the jurisdiction? I mean, would that take this entire issue off the table if we had a reform at that level? Or do you think the problem's still made in here in a system like that?
Yes. So yes. Many of these problems could be resolved if some form of proportional or semi-proportional representation were implemented in order to basically change the structure. I mean, what I hear in your question is the thing I was just telling my students on Wednesday, right? Part of this structural issue is that we have single-member districts, first past the post voting, so that the person with the most votes gets the entirety. And so you underrepresent, who goes to Congress does not necessarily represent the breadth of people and their views, right? And other countries have formulations where set number of districts in a legislative body are distributed in whole or maybe in part by looking at who voted for whom. Of course, this also assumes a number of parties that are representative of that sort, unlike the United States, where there are effectively two parties.
Yeah, but that would change if you had proportional representation. The parties would become vociferous very quickly.
Yes.
Okay. All right. Thank you.
And that's why I was like ready to just say, yes, I agree. But you hit the nail on the head there.
So last time, Mark was talking about these restrictions on exports that some Republicans really wanted. They were very mercantilist, they're very just anti-free trade in certain ways. So like the 1856 slogan of the Republican Party: free speech, free press, free men, free labor, free territory, and Fremont. They didn't include free trade, and the Democrats really were the party of free trade. So Frederick Bastiat, when he's talking about like America, well, I love it. It's the party of freedom, except for slavery and protectionism. And the Republican Party, they hated slavery. But I guess I wonder, how do you make sense of just how much 14th Amendment economic liberty there was when one big element of the Republican Party was this former Whig nonsense with protectionism?
I think I don't have a definitive answer to that, but I think one way to look at it is that questions like this we tend to want to answer by means of defining a right. So we would define the right of contract as freedom of contract or whatever. Whereas I think most of these questions are actually handled by figuring out what the appropriate legislative power is. It's coming at it from the other direction. So you have a very broad definition of the right, which gives rise to the burden on the legislature to justify its exercise of power. And most of the analytic work is now not going to be done by the exact contours of the right, but is going to be done by what the appropriate scope of the power is. And in the Congress's case, it would be its enumerated powers, including the commerce power. And in the state's case, it would be the police power, which would include health and safety, for example. And so most of the debate is going to be on that side of the line, and I'm a little uncertain about how much work originalism does on that side of the line. At least not at the granular level that you're citing examples. I think mostly you're looking for good faith exercises of the police power, and usually towards ends that there's common agreement are proper ends of state governments, health and safety, for example. That's predominantly what state governments are doing. If they're not, doing taxes and subsidies and stuff, but if they're just regulating liberty, they're predominantly doing it for health and safety considerations. There's pretty universal consensus that that's within the police power. Where the debate comes in is what is about the morality part of the police power, and I think most people would include public morality in the sense that it's regulating morality in the public spaces in the public sphere. That would be within state government, parks, streets, roads, that sort of thing. And then that just leaves debatable the degree to which the police power reaches completely private, behind closed doors morality, which is generally speaking not legislated against. Mostly legislation that is ostensibly aimed at that claims a health and safety rationale as well. And so I think that's where the work has to be done.
So this is just a quick follow-up. So I'm wondering, Professor Barnett, so from your perspective, is there a way to say when, so like take right to property, for example, that some minimal basis has been violated or superseded at the state level? So like, how, like, can the whole question of the rights, I guess the question is, maybe to put it this way, how much of the question of the rights can be a question of the conflict or balance of powers between state and federal level? And like, is there at some level a need to talk about when the right is or is not violated sort of on its own terms, if that makes sense?
Maybe it does. I'm not sure I have it. Obviously, if once you've defined the right and you think it's been completely taken away, then that's a violation. If it's not being completely taken away, but you're merely being told how do you exercise the right properly, then the question is the legislation reasonable? I mean, one of the ways of looking at scrutiny, which it should be clear, I favor scrutiny over, for example, the historical analogs approach that the Supreme Court is trying to develop now to avoid scrutiny. One of the ways of looking at scrutiny is to try to is as what my colleague Stephanie Barclay calls an excluder concept. It's excluding improper motives. And so what you're on the lookout for are improper motives that are evidenced by lack of fit between means and ends, rather than trying to prove motive directly or indirectly. You're actually prohibiting the legislature from exercising improper motives, which, for example, take Plessy. Why were they segregating streetcars or railroads? Did they have? Now they claimed it was public order. Is there any reason to actually think that it was public order? They haven't offered none. There's no evidence. There's no historical. Unlike Slaughterhouse, where Miller offers all kinds of reasons why this legislation is reasonable, all of which is dicta if his holding is taken. But there's nothing like that in Plessy. You've got just take your word for it. But obviously, Justice Harlan is realistic about assessing, and this is where Justice Harlan is not being colorblind. He's saying, look at the background context. We know what's going on here. So what's your argument for this? And I think that's kind of what scrutiny should be looking for. And to take a more contemporary, a controversial example, so it doesn't seem like I'm passing the buck here, take gun laws. I think most existing gun laws on the books are probably reasonable regulations on the basis of public health and safety. Most new gun laws that are being proposed to raise the cost of firearms ownership by law-abiding citizens or to stigmatize their exercise by law-abiding citizens because people they don't like that right. And that is going to be evidenced by irrational laws like limiting magazine capacities in ways that make no sense and in fact are not limited for other people who exercise their rights to self-defense like police officers. So that's what you're looking for. You're looking for improper motives, and you detect it not by examining subjective intentions, but by lack of adequate fit between means and ends to establish good faith.